Okay, good morning, Mr. Brado appears on our screen. I think therefore we have everyone that we require for this oral argument. Mr. Hull, my understanding is you are here on behalf of the appellant. And with that in mind, would you care to reserve any time for rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes for rebuttal.
Okay, I will do my best to time my interruption to advise you of your 5 minutes so that I don't interfere with your presentation. Sometimes there's not appropriate pauses, so I may have to just interject, but I will do my best to make sure you know when you get to that point. As you know, it's still your time. You can use those remaining 5 minutes however you desire.
Thank you, Your Honor.
Thank you, counsel. And with that, the court is prepared and you may proceed.
Thank you. May it please the court, I'm Brian Hull on behalf of co-petitioners Dr. Gina Aviato-Bott and Lake Magdalene Emergency Physicians, LLC. The trial court's order denying our motion to determine compliance with the reasonable pre-suit investigation requirements should be quashed for 2 reasons. First, because the trial court did not make express findings of whether the plaintiff had complied with the statute. And second, because the trial court did not conduct an evidentiary hearing. And before getting into these two...
Let me jump in, Mr. Bryan, to kind of frame the issue to make sure where we're at this point. We're dealing with a petition for writ of certiorari. I think we all agree with that, correct?
Yes, that's correct.
All right. And when the petition, and I want to make sure that I have this correctly, and I'm pulling it right here. The original motion to dismiss was filed by defendant Gallon Care, correct? And then you on behalf of Dr. Bott and Lake Magdalene, you filed a notice of joinder of that petition. Is that correct, Mr. Hall?
That is correct from this case. I do want to back up because I believe you said they had filed a motion to dismiss. All of the defendants filed separate motions to dismiss. But when we come to this court, yes, they filed an original petition. We joined in their petition.
And which then leads me to my next thing in terms of framing this. When you joined in that petition, and I quote, here's what you indicated, that you're joining in all sections and arguments of the petition, except for argument section argument section 2, challenging the qualifications of the pre-suit medical expert. Just want to make sure that that's out there. Is that correct?
Yes, that is correct. And the reason for that is those arguments did not apply to my clients, who were the emergency room doctor and her employer. We were not challenging the qualifications to render an opinion on non-clinical care issues, which is what was discussed in that section 2 of the original petition.
Okay, so I just want to make sure that you're not challenging the qualifications of the expert that rendered the affidavit in this case. Based on that, am I understanding that correctly?
That is correct. We are not challenging the qualifications of the expert to render an opinion on non-clinical care issues.
Okay. All right. Then go ahead, sir.
Thank you. But we do, however, join, and we are continuing to argue that the trial court should have made express findings as to whether the plaintiff was in compliance with the statutory requirements to perform a reasonable pre-suit investigation, and whether the trial court should have conducted an evidentiary hearing. So with respect to the first issue, we would submit that the trial court did not follow the instructions of this court to make an express finding of whether the claimant had complied with the reasonable pre-suit investigation requirements.
I guess I'm troubled by that argument, Mr. Hall, because from what I'm hearing you and from what I'm seeing in your brief, you're basically making a quote magic words argument that the court had to go through and indicate in detail. And let me take it one step further. You made reference to a case that basically says, and in support of that position, but that case, the court never made a finding. And here, wouldn't you agree with me that the court basically concluded that the affidavit was sufficient to place you all on notice? So help me out as to why that is not sufficient, and instead you're making this magic words argument.
Sure, and I wouldn't characterize it as a magic words argument. What I would say is there's really 2 components here. And this goes back to the statute where the Florida legislature, in its legislative findings and intent, this is in section 766.201, subsection 2A, And there the Florida legislature says that a pre-suit investigation shall include both verifiable requirements that reasonable investigation precede medical malpractice claims and medical corroboration procedures. And here what happened was the trial court's order focused solely on that second point, the corroboration portion. The trial court just looked at this affidavit and said that it indicated whether or not the claim was legitimate and whether it gave sufficient notice to investigate. That only deals with the medical corroboration portion, but did not deal with whether or not the plaintiff had conducted a reasonable investigation. And that's something that's very significant in this case. And the reason for that is that there were no medical records showing any sort of neurological injury in this case. And that raised the question of, did the plaintiff do a reasonable investigation into whether she had a neurological injury?
And if I may, oh, I'm sorry, go ahead, Judge Liberath. Yeah.
I'm cutting sort of to the heart of it. A lot of the arguments that you have made sound to me like a question of the substantive sufficiency of the corroborating affidavit. And I think we can all agree that the protection that certiorari provides here is for a procedural compliance as opposed to substantive completion, for lack of a better term. And so my question to you is, isn't this more of a question of what your opponent can, I understand what you're saying about the investigation and what the trial judge's findings were somewhat conclusory, but ultimately the question that you're raising here is not procedural compliance. It has to do with the substantive support for the claim that the plaintiff ultimately must prove. And I'm having trouble seeing this as something involving the sort of gatekeeping that certiorari provides here, where there wasn't an affidavit or there's some other procedural, not substantive issue.
Well, I would submit in response to that we are not here to challenge the sufficiency of the evidence. The trial court here made a very limited finding, just said the affidavit here says the claim is legitimate. And our challenge was not to whether there was sufficient evidence to support that finding of causation. There was an open question here about whether or not the expert had made a complete review of the pertinent medical records. And the trial court made no findings on that issue. One of the things that a reasonable investigation under the statute requires is for a plaintiff to consult with a medical expert and obtain a written opinion. And the statute is clear that a person cannot be a medical expert within the meaning of the statute unless that person conducts a complete review of the pertinent medical records.
And isn't this case, though, Mr. Holland, let's look at the affidavit of the expert. Didn't he indicate that he reviewed considerable medical records about the underlying event and the diagnosis?
The affidavit says that he reviewed medical records from Temple Terrace Emergency Department and Advent Health. And he did give a very long description of the events and the alleged medical negligence. And then he gave a single sentence about causation, saying that this caused or contributed to her ultimate neurological injuries. And then in the medical records themselves, once we finally got them, there was no record of a neurological injury. And so we had followed up during that pre-suit period several times on where this neurological opinion came from. And every time we're met with objections. We took the unsworn statement of the plaintiff, which was submitted in the package as part of the motion, and both sides discussed it at the hearing. But there, the plaintiff confirmed that no healthcare provider had told her that she had a neurological injury. So I think what brings us to the problem that we're raising here is that after the plaintiff filed this lawsuit, and after we moved to determine compliance with the pre-suit investigation requirement, the plaintiff serves an addendum to that medical expert affidavit. And in that addendum, the expert says, I saw no reason to review the actual neurological medical records in submitting my initial February 8 affidavit. And he goes on to say why, but he emphasizes that he did not review the actual records. And so our challenge here—
Wait, Mr. Hull, the
Yes.
argument that you're making is that this failure rendered the expert unqualified. Am I right?
Not unqualified, but out of compliance with the requirement that a plaintiff have a medical expert who has reviewed all the pertinent medical records. I would view qualification.
And if I guess I'm troubled by that, because again, going back to the affidavit, he did indicate he reviewed. That's probably, I think the argument you're making will be more for in terms of to attack, maybe not the completion and so forth. But right now, if you look at what's before us, and the whole purpose of the medical malpractice is put you all on notice that a reasonable investigation has occurred, that this is not just pie in the sky of somebody coming in and filing suit. So to put you all on notice, basically he went through the record that he reviewed, and based on the record that he reviewed, he indicated, he goes into detail why, because of the drop in oxygen level, contributed or caused the neurological symptoms that she ultimately sustained. And so perhaps you wanted more about that, but that's for another day in terms of in-depth questioning of the expert itself. But why should that be totally disregarded whatsoever based on the position that you're taking? And this is where I'm having a problem with, Mr. Hall.
Sure. I would submit that in this addendum to the affidavit, the plaintiff's expert backtracks about the records that he reviews, and now he says he did not review actual neurological medical records. And this is a changed position, that he didn't review these actual records, which was a mandatory requirement for someone to be a medical expert within the meaning of the statute. And we submit that this is something that required the trial court to make very specific findings. First, that this expert had actually reviewed all the pertinent medical records. And second, that the plaintiff in general had made a reasonable pre-suit investigation.
I guess I suppose you're making from what I understand, your argument is that you do accept, I think you recognize that this expert reviewed a lot of records, but perhaps not all the records that you're taking the position. Is that what I'm hearing you say?
He did review some records, but he admits in his addendum that he did not review the actual neurological records as he's making this opinion. And we would submit that was a problem that was a big problem here, if he's not going to review all the records when he makes his opinion.
No, that's what's interesting, Mr. Hall. His expertise is that of an emergency room doctor, and he went through this whole affidavit and documenting what occurred at the emergency room setting in terms of all the failures that occurred. And based on those failures, or he came to the conclusion that that has caused or contributed to the neurological. And so now you're saying that he needed to now become an expert, like as a neurologist, to be able to look at exactly, the next step in terms of her neurological problems. I'm having a hard time understanding this.
Sure. The problem gets to the causation issue, because there was no evidence that he reviewed that showed any neurological injury. Nothing in any of the medical records showed any neurological injury. The plaintiff herself says, no one has told me I have a neurological injury.
But didn't he also say that he relied on the plaintiff's symptoms and explained why he didn't need all that other stuff? Didn't he explain that as well? That's what I'm trying to follow your reasoning, Mr. Hall.
Sure. He did say that he relied on the statements of counsel as far as these symptoms, but the statute requires more than that. And let me back up there. I would clarify that we're not saying that an expert cannot rely on statements from an attorney, which is what the expert says he did here, that an expert can rely on statements of various facts, but statements of medical opinion are a different matter, and counsel can't simply give his medical opinion of the injury. The statute specifically requires the expert to make a complete review of the pertinent medical records.
But this wasn't done here. I mean, I don't believe based on his statements, he said he just he relied on the symptoms, the plaintiff's symptoms, as opposed to a quote unquote a diagnosis from a lawyer. So that's a little bit different. And can't an expert rely on that? Just symptoms as opposed to again, he's gathering all this information, and doesn't that corroborate his first affidavit that, yeah, it's consistent with his conclusion that she did experience some sort of neurological injury or problem or whatever it is you want to say.
I think his addendum makes that initial affidavit facially insufficient because it says, I didn't review the actual neurological medical records here. And the statute specifically requires a complete review of all the pertinent medical records. And his second affidavit, his addendum, says he didn't do that. And that's what we submit, require the trial court to make some specific findings as far as whether or not a reasonable investigation had been conducted, whether or not the pertinent medical records had indeed been reviewed. And the failure to, in our position, the failure to make those express findings was a denial of the procedural safeguards of Chapter 766. And that brings me to the second issue, which was the evidentiary hearing. We were not given an opportunity to question the plaintiff's expert about that addendum, either in a deposition or in an evidentiary hearing, and we had asked for both. And this, once we received that addendum, it was a significant change in the position about what records the medical expert had received and reviewed. And it raised in our minds a serious question about the reasonableness of this pre-suit investigation that had been performed, and something that needed to be explored in an evidentiary hearing. And so we would submit that this change in the expert's position, this clarification in the addendum, required the trial court to hold an evidentiary hearing to address and resolve these inconsistencies between the affidavit and the addendum, and to determine whether the expert had, in fact, reviewed the pertinent medical records.
I'm curious, Mr. Hall, help me out. You've indicated that they have not identified tell me, what evidence do you think you would need or to put you on notice for any type of hearing? You're asking for an evidentiary hearing. What information do you need?
What do we hope to obtain from an evidentiary hearing? We would like to explore the inconsistencies in those affidavits, to ask the expert about the addendum that he filed post lawsuit.
Doesn't the addendum already set forth that, hey, it's an addition, I've now gotten information about symptoms, I don't need to look at all the other stuff? The addendum says that. His first affidavit says, I reviewed all these records. So what else is missing?
Well, he's conceding in that affidavit that he did not review the actual neurological medical records.
Okay, and he basically said, I don't need it because I know her symptoms, so I don't need to go there, because if he then much to do that, he's not a neurological expert, and now he's going to opine an opinion on a neurology, which he's not qualified to render. So it's almost like a double-edged sword. So what else do you need from that evidentiary hearing that's not before us right now?
Well, I think that evidentiary hearing was something.
You're about at 15, so you may want to tailor your remarks accordingly.
Thank you.
And I apologize, Mr. Hall,
No,
peppering you with questions. I should kind of sit back and give you an opportunity.
No, that's fine. I would submit that under this court's case law, that an evidentiary hearing is something that was necessary, especially under the facts of this case, where we have an affidavit that was later modified post-suit, to determine whether or not the plaintiff had indeed conducted a reasonable investigation into whether or not there was a neurological injury, when none of the medical records disclose any sort of neurological injury. And so in sum, we would ask that this court quash the trial court's order and direct the trial court to conduct an evidentiary hearing after giving us the opportunity to depose this expert, especially about this new post-lawsuit addendum. And the trial court should then make express findings as to whether or not Ms. Stokes complied with the reasonable pre-suit investigation requirements of Chapter 766. And I'll save the rest of the time for rebuttal.
Thank you. Mr. Barotto, you have your
morning, Your Honor.
ability to
Good morning,
respond.
everybody. May it please the court. Before starting my argument, I do want to apologize to this court. As you can see, I'm not wearing a tie. This is not out of a disrespect for this court. I recently had spinal surgery. If you could see, I have a little bone stimulator that I'm wearing here around my neck. So that's the purpose of my appearance today. Again, I don't want that to be viewed as any disrespect or anything, but I wanted to let the court know that to begin with. And I'm going to try to be as brief as possible. I think the court has pointed out essentially what our argument is. You know, the Florida statutes require exactly that, a reasonable investigation, not a complete investigation, not an overwhelming investigation, a reasonable investigation. And we believe in this case, we went above and beyond what would be required as a reasonable investigation. We got a highly qualified expert. And one of the things we did attach, and which is part of the record, is a copy of his CV, which sets forth his qualifications over 20 years as an emergency room doctor. And he reviewed, and this is something that has been used in this court a lot, the pertinent records. What are the pertinent records in this case? The pertinent records are what happened in that emergency room while my client was there, which is a subject of the alleged negligence. When you look at those records, there are documented instances of hypoxia, lack of oxygen to my client. At one point in time, it was documented over 30 minutes. That in and of itself is neurological injury, or when you don't have oxygen, that's what happens. So, you know, by counsel saying that my expert didn't review the pertinent records, that may be, as the court says, those records may be pertinent for another day to determine the extent of damages. But when you have a patient in an emergency room that is without oxygen for 30 minutes, that in and of itself is evidence of injury. And for example, if this case goes to trial and I place my expert, Dr. Ferre, on the stand, and I ask him about the standard of care, which he's highly qualified to testify on, and then I ask him, well, can you tell me if that negligence caused or contributed to this neurological injury? I can guarantee you the other side is going to object and say, hey, he's not qualified. You know, you can't have an emergency room doctor talk about neurological injuries. And this is why the court again said, you can't have it both ways. But what an emergency room doctor can say is, when I have this amount of hypoxia, this amount of lack of oxygen, which is documented in the medical records that I have before me, which he has spent 7 pages dissecting and placing in his affidavit, and he is told this patient is now having memory loss. She's having problems with concentration. She's having other neurological symptoms. He can reasonably conclude, when you have somebody that is deprived of oxygen for half an hour in the emergency room, it is reasonable to conclude that these symptoms are as a result of that. But the pertinent records are those of the hospital, which were reviewed and were summarized. He did a complete review. He did a review of everything that he needed to review in order to determine whether or not there was negligence, more likely than not, and whether or not that negligence caused or contributed to injury, which he did. And he verified that in the affidavit. Now, pre-suit is not just an affidavit. It's unsworn statement. My client's unsworn statement was taken. She was asked a number of questions about what her injury was, what her symptoms were, et cetera, et cetera. All that information was relayed to the expert after the fact at that point in time, but we knew about that prior. But again, I believe that a very reasonable, a very detailed investigation was done. And again, if you look at the case law, what is the purpose of pre-suit? And the case law has said that it established that the statutory screen does not require the corroborating expert's affidavit give notice of every possible instance of medical negligence and every type of damage. No, it is to say, hey, we believe there was negligence and we believe it caused damage. That's what my affidavit says. That's what the entirety of pre-suit says, when you combine everything else in terms of the information that was exchanged during the 90 days, the unsworn statement of my client and everything else. So I think this affidavit goes above and beyond the reasonable expectations of pre-suit. And when we look at what the court found, the court actually says that. If you look at the transcript, I'm referring to the court transcript of page 43, the notice of intent in conjunction with the affidavit, Dr. Ferre, the purpose of which is to indicate that a claim is legitimate or not legitimate. He's saying in his affidavit that claim is legitimate. That was sufficient to place all defendants on notice such that they could investigate the issues set forth. That was a court's finding. That is in the court transcript. Was that word for word in the order? I think that's what they're questioning, but she clearly made that decision at the time of the hearing and clearly indicated that in the transcript. She goes on to say in the transcript on page 7 of the expert's affidavit, he goes into standard of care, breach of the standard of care, as well as causation, sufficient to put you on notice to do your own investigation. These were all findings of the court. So the order is sufficient, and when you include the transcript, she clearly made these findings that the affidavit was sufficient. And then lastly, the issue about an evidentiary hearing. Again, there was all this information that was provided to the court in order for the court to make this decision. I want to remind this panel, this was a 1-hour hearing. This wasn't a motion calendar, 6 minutes, 10 minutes. This was a 1-hour hearing that was set at the request of the defendants because they wanted all this time to argue their motion. So we spent an hour arguing, which is probably more than we would have had for an evidentiary hearing, where all the information was in front of the court. All the unsworn statements, all the information that was exchanged during pre-suit, the court held all that. They heard all that. There is no reason to bring my expert in and ask him questions about his affidavit. It's all there. It's reasonable. So again, the ruling by this court that there was no need for the evidentiary hearing, I believe is true and accurate because she had everything that she needed that she would have had we had an evidentiary hearing. Everything was discussed. Everything was argued during this 1-hour session. So again, with that, I thank the court for its time and for patience to listen to me. If there's any questions, I'll be more than happy to answer. If not, we go back to my my response to their petition and reiterate all the arguments there. But again, in conclusion, this was a reasonable investigation. The trial court looked at all the evidence, determined it was reasonable, entered an appropriate order, and the cert here should be denied. Thank you, everybody, for your patience and your time.
Thank you, counsel. On behalf of the panel, we extend our best wishes for a very speedy recovery. And
Thank
hopefully
you,
you
Your
don't
Honor.
have to wear that device very long.
Yeah, this is I appreciate it. It's a little, and I'm glad I'm not getting static because it emits a radio frequency, something to help the bones heal. So when I pick up my phone, I get all this static. So I was testing it this morning just to make sure that wouldn't interfere with the court today.
Thank you. Mr. Hall, you have 4 minutes remaining, counsel.
Thank you. I think here we can't just assume that there was a neurological injury, that this is something that needs documentation. There needs to be documentation of a medical injury. And in this case, the actual records here showed there was no neurological injury. There was no doctor who evaluated her that found a neurological injury, which was a point that she herself confirms. And when we received the medical records that this expert had actually reviewed, it came to somewhere in the neighborhood of 88 pages out of the several thousands of pages of records that the hospitals had in this case. And so in this case, we had no doctor evaluating her that found a neurological injury. She confirmed that. And in the pre-suit affidavit that the expert provided, he later admits that his opinion was not based on his review of the actual medical records. And so there was no, we would submit that an evidentiary hearing was necessary so that we would be able to question this expert about his post-suit affidavit and his changes that he made in this addendum. And here in our motion, we asked the court to determine whether or not the plaintiff had complied with the reasonable pre-suit investigation requirements under these circumstances where we have an expert changing his position about the medical records that he reviewed and whether or not those records, those actual record, he could have an opinion about a neurological injury where that was not documented in any of the actual medical records. And so we would submit that the trial court should have made a specific finding, an express finding that a reasonable investigation had been performed, and that the trial court should have had an evidentiary hearing to address some of the significant questions that we had raised about this new change in position about the expert's opinion and what it was based on. So we would ask that this court quash the order of the trial court, allow the deposition of this expert, and conduct an evidentiary hearing followed by specific findings on whether or not the plaintiff made a reasonable pre-suit investigation under these facts and circumstances.
Thank you, Mr. Hull.
Thank
Thank
you.
you both for your presentation. I guess I'm to ask you to transition from this electronic courtroom back to the other side, wherever that is, so that we might move on to our second matter. Please have a wonderful holiday, everyone, and we hope to see you again in the future.
Same to you and everybody,
Thank you.
all the panel. Thank you very much for your time again.
Thank you.